Trump versus the Supreme Court. The constitutional crisis nobody is explaining. Donald Trump's campaign against America's judiciary is not just another institutional clash. It is a test of whether constitutional government can survive the erosion of restraint. Something unusual is happening inside the American government. After the Supreme Court blocked his tariffs, Donald Trump didn't just criticize the ruling, he suggested Congress should punish the judges who made it. Legal experts are calling this a breathtaking breach of constitutional norms. But here's the real question: is this just political rhetoric, or the beginning of a structural conflict between the presidency and the courts? Because if it is the second, the implications are much bigger than one legal decision. In the architecture of the American Republic, the judiciary was designed to be the least dangerous branch. It commands no armies, raises no taxes, and passes no laws. Its authority rests instead on something more fragile: legitimacy. That legitimacy depends on a shared assumption that judges interpret the law rather than serve power. Donald Trump's escalating attacks on America's courts now threaten that assumption more directly than at any point in modern American history. His rhetoric against rogue judges, his proposal that Congress punish members of the judiciary, and his public denunciation of even his own Supreme Court appointees mark not merely a quarrel with rulings but a challenge to the institutional independence of the bench itself. The stakes extend far beyond a tariff dispute or a nomination hearing. At issue is whether the unwritten norms that sustain constitutional balance in the United States still function, or whether they are quietly dissolving under the pressure of presidential politics, a ruling that changed the temperature of constitutional conflict. The immediate trigger for the latest confrontation was a decision by the Supreme Court of the United States striking down tariffs imposed by Mr. Trump under the International Emergency Economic Powers Act. By a 6-3 majority, the court ruled that the statute did not authorize the president to impose tariffs, authority that belongs, under the Constitution, to Congress. The legal reasoning itself was orthodox. Congress controls trade powers. Emergency statutes are interpreted narrowly. Executive authority cannot expand itself through reinterpretation of legislative silence. The political consequences, however, were anything but routine. Among the justices joining the majority were two Trump appointees, Neil Gorsuch and Amy Coney Barrett. Their participation transformed a technical ruling into a symbolic rebuke. Presidents often criticize courts. They rarely attack their own nominees for failing to display loyalty. Mr. Trump did precisely that, declaring their decisions sickening and calling for legislative action against judges who obstruct executive policy. That suggestion marked a constitutional escalation. From disagreement to discipline, criticism of judicial decisions is normal in American politics. Calls to punish judges for issuing them are not. According to Barbara McQuaid, writing in Bloomberg, the proposal that Congress enact laws targeting judges who rule against the president constitutes a breathtaking breach of the presidential oath to support and defend the Constitution. Her choice of words is precise rather than theatrical. The Constitution creates three co-equal branches of government. It does not permit one branch to discipline another to perform its assigned role. If courts risk punishment for interpreting statutes independently, they cease to function as courts at all. Instead, they become administrative appendages of the executive. Even if no such legislation is passed, and it certainly will not be, the mere suggestion alters the institutional climate in which judges operate. Independence depends not only on legal safeguards but on expectations about acceptable political behavior. Once those expectations shift, so does the system. America has seen this before, just not like this. American presidents have long clashed with the judiciary. Thomas Jefferson denounced Federalist judges as partisan conspirators. Andrew Jackson dismissed a Supreme Court ruling with the observation that the justices must enforce it themselves. Franklin D. Roosevelt attempted to enlarge the court to secure favorable rulings during the New Deal, yet each episode preserved a boundary. Presidents contested judicial authority. They did not threaten retaliation against individual judges for exercising it. Mr. Trump's approach crosses that line. His rhetoric does not merely question legal reasoning. It challenges judicial legitimacy as such. That distinction matters. Courts can survive criticism. They struggle to survive intimidation. A judiciary that is starting to speak differently, the most revealing signal of institutional strain comes not from the executive branch but from the courts themselves, according to reporting by the New York Times. Federal judges are increasingly concerned about the risks associated with vehemently opposing presidential policies. Some are responding by abandoning the judiciary's traditional language of restraint in favor of more direct, and occasionally dramatic, warnings. One judge compared the administrative burden imposed by new cases to a demigod's battle against a mythological monster. Another cited a 1970 protest song in opposition to National Guard deployments. A third likened attempts to rewrite historical narratives to the Ministry of Truth in 1984 by George Orwell. Judicial prose rarely includes mythological metaphors, protest music, or dystopian literature. When it does, it signals anxiety about institutional survival rather than disagreement over statutory interpretation. Judges are not merely deciding cases. They are attempting to communicate urgently. The quiet emergence of loyalty signaling in confirmations, even more consequential than rhetorical clashes with sitting judges, is what is happening to those seeking appointment. During confirmation hearings, nominees avoided stating plainly that Joe Biden won the 2020 election. Instead, they relied on formulations that emphasized certification rather than outcome. Such linguistic maneuvers may appear trivial. They are not. Lifetime judicial appointments depend on the expectation that judges will be insulated from political allegiance tests. When nominees calibrate their answers to avoid contradicting presidential narratives, they introduce a new criterion for advancement: interpretive loyalty not merely to the Constitution but to the executive. As Jeffrey Toobin observed, there is special peril when judges agree to demean themselves in this fashion. The danger lies less in the answers themselves than in the precedent they create. A judiciary shaped by loyalty signaling cannot easily remain independent once installed. Why does intimidation work? Even when it fails, Mr. Trump's critics often assume that proposals to punish judges are purely rhetorical gestures. In legislative terms, they are right. Congress is unlikely to enact measures that directly sanction courts for issuing unfavorable rulings. But intimidation does not require legislative success to be effective. Presidential rhetoric alters expectations. It mobilizes supporters. It signals consequences. It creates reputational risk for judges whose authority depends on public acceptance of their neutrality. Over time, such signals reshape institutional behavior. Even if no formal rules change, courts rarely collapse dramatically. They adapt incrementally. That is how independence erodes. Congress, guardian or bystander. The Constitution assumes Congress will defend its own authority when the executive expands too far. Historically, it often has. Legislators understand that weakening courts weakens Congress itself. If the judiciary cannot restrain presidents, legislatures must do so directly, and they are poorly equipped for the task. Yet modern congressional politics complicate that calculation. Party alignment increasingly outweighs institutional loyalty. Legislators now operate less as guardians of constitutional structure than as participants in partisan coalitions. A Congress described by critics as submissive may hesitate to confront executive overreach even when constitutional balance requires it. The crucial question is not whether punitive legislation against judges will pass. It is whether Congress clearly signals that such legislation would be unacceptable if proposed seriously. Silence in constitutional politics is rarely neutral. The strategic logic of judicial confrontation. Mr. Trump's approach to the judiciary is often interpreted as impulsive. In fact, it follows a recognizable political logic. Modern executives increasingly govern through emergency powers, administrative agencies, and regulatory interpretation rather than legislation. Courts therefore become the principal obstacle to presidential ambition. Undermining judicial authority weakens that obstacle. Even unsuccessful attacks on courts produce strategic advantages. They mobilize supporters, delegitimize adverse rulings, and pressure judges to consider political consequences alongside legal reasoning. The objective is not necessarily to control courts directly, it is to change the environment in which they operate. The judiciary's structural vulnerability. Unlike presidents or legislators, judges cannot appeal directly to voters. Their authority rests on compliance rather than enforcement. As Alexander Hamilton wrote in Federalist No. 78, the the judiciary possesses neither force nor will, but merely judgment. That formulation assumed presidents would accept judicial judgment even when inconvenient. The American constitutional system depends on that assumption remaining broadly true. Once it weakens, courts must rely increasingly on public opinion to sustain their authority. Yet appeals to public opinion risk making courts appear political actors themselves. This is the judiciary's central dilemma. Neutrality sustains legitimacy. Visibility protects survival. The two are increasingly difficult to reconcile. Norms, not statutes, hold the system together. America's constitutional structure contains few explicit protections for judicial independence beyond tenure and salary guarantees. Its durability depends instead on norms, shared expectations about acceptable behavior between branches of government. Presidents criticize courts but do not threaten them. Legislators disagree with rulings but do not punish judges. Nominees answer factual questions without hedging. These conventions are not written anywhere. Yet they sustain everything. Mr. Trump's rhetoric does not violate the Constitution directly. Instead, it challenges the norms that make the Constitution workable. That is precisely why it matters. Constitutions rarely collapse through formal amendment. They erode through reinterpretation of what once seemed unthinkable, a cumulative transformation. None of the developments now unfolding would, in isolation, threaten American constitutional stability. Presidents have criticized courts before. Nominees have evaded uncomfortable questions before. Congress has tolerated executive overreach before. What is new is their convergence, simultaneous pressure on judicial legitimacy, confirmation culture, legislative restraint, and executive rhetoric produces cumulative strain. Each episode shifts expectations slightly. Together they reshape the operating environment of the constitutional order. The result is not crisis, it is drifting, and drift can be more consequential than crisis because it is harder to detect, and easier to normalize. The Republic's quiet stress test: the American judiciary remains powerful, respected, and operational. Its rulings continue to shape policy. Its authority remains formally intact, yet constitutional systems rarely fail abruptly. They weaken gradually as norms erode and expectations adjust. Mr. Trump's campaign against rogue judges may never produce punitive legislation. It may not alter court decisions in the short term. It may not even change institutional structures directly, but it shifts the boundaries of presidential behavior, and therefore the boundaries of constitutional politics itself. The United States has long relied on restraint rather than enforcement to preserve the independence of its courts. The question now is whether restraint still commands loyalty in a political system increasingly organized around confrontation. For 2 centuries, America's judges have spoken with the authority of law. Whether they continue to do so may depend less on what they write than on whether the rest of the government still chooses to listen.